So guys, as we know, we're part of the Connect with Chamber series. This is a value add to our community with regards to sharing information, keeping our members informed, and as well as the non-members, but the community at large, just to have everybody intact of what's alive and what's to be done in the line of business. So with that, we are just going to be sorting out a bit of Zoom etiquette. Remember your mute button. We need to all be muted when the presentation starts. Let's see, there's still so many people coming in. So what I'll do is I'll be the person letting everybody in, and Serene is going to be our host today doing POPI, and then we'll take it from there. Welcome on board, Serene. It's great having you here.
Thanks so much. Thank you for having me. Are you happy for us to start, Sam?
I am. I'm just going to make sure that you host, and then we can take it from there.
I see the share screen button. Yes.
Hi, Brian. Yes.
Hi. Am I able to record?
Yes, we are recording the session. No problem. We can share the session.
All right. Thank you.
No problem. No problem. Just a note, everybody. While we have some guests still coming in the room, we are going to be taking the questions in the chat box, which is on your panel at the bottom. Kindly place all questions in there, and what I will be doing after the session is Serena and myself will be working through the questions for a detailed document. We're going to send it out on email to everybody so that everybody can have the same info on a dialect, if that makes sense. So there'll be no questions asked after the session, but Serene will share her screen and do the presentation accordingly. All right, okay. Let's just see here. Just want to make Serene, I just want to make you the host before we start. Then you can share. All right, guys, have a great session. Thanks for joining us.
A bit of feedback, all right? Let me share my screen. Apologies. Just trying to get that open. My computer seems to be a little bit slow today. Current slide. Right, is that, I just want to make sure, is my PowerPoint busy opening now, Sam?
I'm looking, I'm just having a look, see if it's coming through. It's not on yet.
Right, sorry, my computer just seems to be a little bit slow today. I'm in fact on a different computer than I ordinarily work from, so that's why there's a bit of a lag.
No problem. I'm sure everybody's dying to hear what the protection of personal information is all about. So don't mind waiting for your laptop.
I do apologize. I see my cursor doesn't seem to want to work. I'm just trying to figure that out. Here we go.
So guys, just a bit of background on Serene. She is a limited
have you been asked
court,
in
part of
school
Incorporated and lives in Port Elizabeth, so she's streaming in from PE. I used to work with Serene at Global Business Solutions in East London, and it's great to see her here.
Everyone else has a paper.
Thank you, Sam. Sam, I just want to ask, is it showing now, my screen?
No, not yet. I wonder why. Let me just go and let me claim back home and then see if I can make
Sorry, yeah, perhaps I do apologize. Sorry. Wait, there we go. Okay, can you make me the host again? I really do apologize. Sorry.
No problemo. Now.
Screen. There we go. Okay.
There we go. It's coming on.
There we go.
All right. Perfect.
Thank you. And is it the PowerPoint that's available is showing now?
It just says here at the moment, Serene Lepera has started sharing screen. I'm sure it'll come in a moment. not
The
on yet, but
screen
it is
sharing is
starting.
paused, I see.
Yeah.
Folks, I do, yes, but perhaps while my computer is catching up and we sort out the technology, I'm an attorney for Kirschmans Incorporated and a consultant for global business solutions. I spent 4 very happy years in East London, and attended many events at the chamber. So it's very lovely to be back in a way. I know I'm not physically back, but it's lovely to be amongst you all today. I'm just trying to still open my slideshow. Admit, I see there's some people still joining us. Folks, if you wouldn't mind, I do apologize. Just a few minutes, 3 minutes until I just have this sorted out. I really do apologize.
Okay, while Serene is just sorting out her laptop for the presentation, we do have some marketing avenues that maybe we could run through. If anybody's interested in joining the breakfast, we've got a Secretary's Day breakfast coming up on the 2nd of September. So that's also a great interaction for the ladies. If there's any guys out here on this webinar today, if you'd like to spoil your admin staff, they're more than welcome to come through. We are looking for a maximum of 50 though, with strict protocols in place. So yes, that's also a great way for us to connect. Just a note on our memberships at this stage, there's a lot of new exciting projects coming in. We have a whole strategy session for next year that's going to be confirmed and decided on for September month going for our quarters. So please do look out for all our events, our marketing avenues, and how to get involved. It's going to be quite interactive. So yeah, we do have a coffee chamber bar. So that whole set is where we've got our members who come to the chamber. We help like host coffee. We do a glass of wine if anybody would like a glass of wine. Now that the alcohol and the bottle stores are all open, you can maybe start sharing some wine. But yes, we try and connect with non-members. If there are any non-members on this platform today, we'd love to be in touch and chat away on the membership benefits and the values back to you, to your business. Cool. I must see Serene's really struggling to get her laptop to view. Shame. So with regards to POPI, I'm sure you've all known already that it came into effect on the 1st of July 2020. The Act was passed, with regards to a grace period, but the grace period is almost a full year away, but there's a lot of protocol that needs to be done from the company side of things. So with POPI being so hot topic at the moment, it's nice to see that there's such a good audience on our platform. So just a reminder on your mute button, just to make sure that everybody is muted. But yeah, if there's anybody that would like to maybe share a topic of interest that they would like to see on the Connect with the Chamber, it would be great to have you email me. My email is members with an S at the end @bkcob.co.za, to which then I can take your topic to heart, and we can definitely try and host a provider who can share their topic of choice in their special field or their expert field. So yes, I'm here to guide you as a member liaison and events and membership indirect. So anything goes when it comes to an event. If anybody would like to sponsor, we look for sponsorships, but we definitely need to have our members strong fold in communication. So has anybody got any questions for now while we're waiting for Serene just to sort out her laptop? You can unmute. For the guys out there as well, just a note, our annual golf day, we are still planning this. Ladies, we want to put the challenge out there as well to say, come on, we're going to beat the guys in 4 balls. So if anybody's keen to sign up for a 4 ball, the discussions on this is actually starting to be released in mid-September. So we'll be able to sort out who's coming on board for the golf day. Should be a lot of fun, a lot of crazy time. Just a reminder on our strict protocols in place, we won't be doing normal prize giving as in the establishment where the golf will be hosted, but at least we will be able to do an online prize giving and you know, interact on a new level. Business is certainly unusual and we are trying our best to sort out where we can. All right. This one is just Serene. I'll be with you everybody in a second.
Hello, Sam. What's the password for PC?
Are there? Sorry, who's missed that?
It's Gordon, yeah. I'm trying to log in on my work computer and it's asking me for a password, which I don't have.
Okay, no problem. I've got the password. Hold on 2 seconds. Should be able to sort that out for you, Gordon. Hold on 2 seconds for me. All right, so password that you're looking for is 971671. If anybody is struggling to log in, that is the password. 971671. Okay, let me see if I can make Serene the host. I don't need to share my screen. Serene's back. Okay, here we go, Gordon. Just sort out here. Okay. Serene, I've made you the host. I hope you can hear me. Great. Okay, guys. Sorry about all these technical difficulties. I know East London's also terrible with connectivity issues, but hopefully we can get our session on board. Hi, I see Gordon's in the room. Thank you very much for joining, everyone. It doesn't seem like Serene's able to share her screen. I don't know why, Serene. Hold on 2 seconds.
I'm so sorry. It keeps saying my screen sharing is paused. I don't know if that's something on your end.
No, it says here that you are host. I must reclaim. Maybe I must just take it back. Hold on 2 seconds. Okay, it says I'm
I have a whole team of ladies trying to help me out. We're not sitting idly. We really are trying our best.
It says that you are host, so, and it's not paused my side.
It's for some reason it's saying that it's paused. Resume share. None of that's working.
Serene, you've just come onto my screen. It's Shanae here. I can see you and it tells me that your screen is now sharing.
Hi, do you see the actual the screen though? Do you see the?
I see you.
Okay, you see me, but you don't see my.
But it says screen is now sharing, but I only see you. Serene has started screen sharing.
No, I really, as I say, I have very capable people around me, and we're all struggling. We do this all day, every day for global, and now somehow it's just stuck. Should we try just a new share?
You want to maybe log in with a different laptop?
Folks, would you perhaps, I don't want everyone to sit around and wait for me indefinitely. Would it perhaps be easier if we just start at 12 while we give us 15 minutes to just try and sort this out? Is that all right, Sam?
Shame. I think everybody's got a schedule, but we'd have to ask the platform. Shame, I'm not sure.
Okay.
Would everybody be comfortable starting? We are already 42 in.
Yes.
Let me know if there's an issue for timelines, guys. Okay, there is a lot of load shedding happening, so we are having those.
Yeah.
Sari, could you not email me the slideshow maybe?
Yes, let me do that. Okay, let's hope that's just another 3-minute delay then. Let's just try that.
Okay. Okay, so let's just get this through onto my email. Sorry for the delay, everybody. 21 minutes. Okay, guys, I've received the PowerPoint. Let me share the screen. Here we go. Great stuff. Thanks, Sari, for sending through.
My alternative suggestion was going to be that that I simply just record a session and then we share that. But I think if we're able to start it this way, that would obviously be great.
No problem. Okay, can everybody see the screen?
I can see it. Thanks.
All right, perfect.
All right, thanks, Sam. So I'm just going to have to prompt you to go ahead. All right, can you perhaps just, make it a slideshow? Awesome, folks. All right, thank you. I do apologize for that. Here we go. So I really appreciate you standing by. So the Protection of Personal Information Act has been in the pipeline for many years. From 2013, we've heard rumblings of it. And even before that, Sam, if we can just go to the next slide, even before that, there's been a bit of a progression in terms of attempts to try and regulate personal information in organizations. So we've had, obviously it all starts with the constitutional right to privacy, and subsequent to that we've had the Promotion of Access to Information Act, we've had the Electronic Communications Act, and then aspects of the Consumer Protection Act, which also was attempting to regulate our right to privacy and our right when it comes to our personal information to be regulated. And what the Protection of Personal Information Act does is it attempts to consolidate all of those aspects into one overarching piece of legislation to protect us. And then, so as we can see there in 2013, it was promulgated partially, but if we look at the next slide, we'll see that on 29 June, the 30th of June this year, it formally came into force. I think a lot of us can be forgiven for having missed it because we were so caught up with all things COVID, but it came into force now entirely. So, Sam, if you wouldn't mind just going on to the next slide. From the 30th of July, the 1st of July, 30th of June, it came into force. So our last day, the Act does, however, provide us with the grace period of 1 year. So there's a 1 year period in which organizations can become compliant. So the last day of compliance, or the last day for you to become compliant, is going to be the 30th of June of 2021. Now that seems like a long time, a year seems amazing, but the reality is that it is a process to become compliant. It's not as simple as just quickly checking your policies. So I really would encourage you to make use of this period. Folks, so the purpose of the Act is obviously, as the name suggests, to promote the protection of personal information, providing minimum requirements for the processing of personal information, codes of conduct, provide the rights of persons regarding unsolicited electronic communications, which obviously is something we'd all be happy to hear, and then regulating the flow of information in and out of South African borders. And then crucially, as you can see there in the top right corner, is the establishment of the information regulator. Now, the information regulator has now officially been established, and it's headed up by an advocate, and funds have been made available by government. And what the information regulator is going to be, the powers are to monitor compliance. That's always when I'm giving advice to clients, in any kind of legal aspect, the question is always, well, what happens if I don't? And that's where enforcement mechanisms come in. And that is the job of the information regulator, is to monitor for compliance and then to enforce the provisions of the Act. And how they'll do that is they're able to do random audits of workplaces or of organizations to check for compliance. And then obviously also to listen to complaints. So where a data subject feels that there's been a breach of their rights in terms of the Act, and they listen to complaints, their powers even stretch as far as to make funds available to private individuals who feel that they've suffered loss, financial loss, as a result of a breach. So they're able to, from a financial point of view, support data subjects to fund litigation in terms of civil suits when it comes to breaches. So that watchdog, as it will, really has very far-reaching power. So the crux of the Act is really, in a nutshell, is shown in this slide. Is it talks about, as an organization, how you get personal information into your organization, and then once it's there, what your responsibilities are towards the data subjects. Now, there's a lot of terminology here that we'll still unpack, but that is the crux of what the Act tries to regulate, is we want to make sure that you have information, personal information, coming into your organization in a regulated and proper manner, and then once it's there, that you respect the rights of the data subjects. So if we can just go to the next slide. The application of the Act is important. As I say, you can see there I've underlined a few of the terms because they're quite loaded and need to be defined. But the Act applies to the processing of personal information which is entered into a record by or for a responsible party, and this responsible party needs to be domiciled in the Republic, or even if they're not domiciled in the Republic, then they need to make use of automated or non-automated means within the Republic. So we're going to unpack those concepts because they're crucial for us to understand. So we can just go to the next slide. We can see that as I said, the Act talks about the processing of personal information which is entered into a record by a responsible party. Now, what very often people would like to think that, well, I mean, I don't process information. I don't do anything with information that I have at my disposal. Now, if we look at what the definition for processing is, I think it's quite easy to see that a lot of us do, in fact, process information. So it talks to the collection of information, receipt, use, modification, transmission, distribution, storing, archiving, retrieval. So if we now think about if your organization has, let's say, info at Global Business Solutions, for instance, how often do you receive perhaps even unsolicited CVs of people? So people send you their CVs even though you didn't specifically ask for that. Now you are processing, you have collected, you have received, you are storing, even if you don't intend doing anything with that information. And if we go on to the definition of personal information, you can see that it needs to relate to an identifiable, living, natural, or existing juristic person. It's any information related from their age up until their well-being. We'll look at that definition still. The educational information, medical background, financial, criminal, or employment history, identifying numbers or symbols. So that can include obviously telephone number, ID number, email address, biometric information, and you can see there even opinions. So it really is a very, very wide realm. It's not just personal in terms of what we think to be private or confidential. It really is a range of information about us. And I think if we just look at those first two columns, it's quite obvious that this is where HR comes in. All of this, all of the processing and in the personal information itself would often happen in the HR offices and the HR manager's office. And then being entered into a record. So regardless, the form doesn't matter. It doesn't matter whether it's on a hard drive or in a file or in the memory of your printer or your scanning machine in the office. It's entered into a record. And if it is then in the possession of this responsible party, regardless of who captured it and regardless of when it came into existence, then the Act applies to you. So we're not saying automatically it's prohibited, but we're saying if all of these requirements are met, then the POPI Act or the POPI Act applies to you. So if you can just go to the next slide, you'll see that there are certain exclusions from the Act. Obviously, the Act doesn't apply to all of that information being held for purely household activities. So you don't now have to go and erase your little telephone book that you have at home with everyone's telephone numbers in there. I don't know whether anyone even uses that anymore. And also when it comes to information that has been de-identified to the extent that it can't be re-identified again. So if it's simply information that I'm holding for purposes of, for statistical purposes, for my archiving purposes without any names or information attached to it, then the Act also doesn't apply to that. And then also certain, obviously, legal aspects. So if it's national security, executive council, those sorts of things relating to judicial functions of court, the Act also doesn't apply to those aspects. All right, you can just go to the next slide. As I said, definitions are crucial in the Act. So we can just have a look. A data subject is that person to whom the information relates. Sam, you can just go, these next slides we can go through rather quickly because they're quite simple. So data subject, as I said, it's the person to whom the information relates. The next slide, de-identify, as we said, will be a very important concept also to understand because it is possible for you to escape the application of the Act if you have de-identified the information. So simply having, as we said, for statistical purposes, people's information around age, weight, educational background or whatever, that's perfectly acceptable as long as there's no way to determine who it relates to. So anyway, de-identification talks about any way that you can delete information that identifies that person. All right, thanks, Sam. You can go to the next slide. And then personal information, folks, obviously, as I said, a big definition, yeah. It needs to be about an identifiable, living, natural person, or an existing juristic person as well. And then those of us who are familiar with employment equity, that paragraph A will be familiar to us. It's all of those listed grounds for discrimination. So race, gender, sex, pregnancy, marital status. So it's any information relating to those aspects of a person, of the data subject. Any information related to education, their medical background, financial background, criminal, employment history. So we can imagine now, again, as I said, from an HR point of view, you will have all of this information at your disposal. You'll know what somebody's criminal record looks like, what their employment history was. Very often, all of this information is disclosed in a CV. So you have to be very, very careful. As I said, that sort of info@ kind of email address often is a very high risk file or folder because it contains so much personal information, regardless of the fact that it was unsolicited. When you just go on to the next slide, you'll see that that definition carries on. Those identifying numbers, symbols, email addresses, physical addresses, biometric information. So we have to be careful. I know very often, I mean, companies have biometric systems in terms of clock-in. So that is also seen as personal information that is regulated in terms of the Act. We'll see in a moment how it's regulated, but it's regulated by the Act. You can see it even carries on to say correspondence sent by that person that is implicitly or explicitly of a private or confidential nature, or correspondence that would reveal the contents of the original correspondence. So it really extends quite far. And then opinions of another person about that individual. So this is a reference letter. Your former employer's reference letter constitutes personal information because it's their opinion of you, and that's included in the definition of the Act. All right, so we have to be very, very careful around attempting to exclude something from the definition of personal information because you see it's very, very broad. We can go to the next slide, please, Sam. Important, and this isn't the definition of the Act, but it's important to note that Section 12 of the Act specifies that personal information must be collected directly from that data subject unless, and then there's certain exclusions. So obviously if it's part of a public record that's deliberately been made public by the data subject, they've consented to you collecting information elsewhere. So you'll often sign forms if you perhaps have a broker helping you with your medical aid, your doctors, for them to disclose information to external sources. You'll have to consent to that. Or alternatively, if the collection would not prejudice a legitimate interest of the data subject, that's a further exclusion. Now, processing, as we said. Processing isn't simply physically doing something with that information, simply having it, having collected it, received it, recorded it, stored it, collated, updated, modified, and you can see there it carries on. So we genuinely have to consider the entire life cycle that information could have in your organization. As we said, when it enters the organization, how long you have it, what you do with it once it's there, and then ultimately also the destruction thereof. All of that is included in this definition of processing. And then the next slide is record. Sorry, record, not the verb, it's the noun. What do we mean when we say it entered into a record? It doesn't have to be a hard drive. It can also be, I mean, back of a napkin. If you wrote someone's name and telephone number on the back of a napkin, that is a record of personal information, and you have processed it. Obviously, if it's purely for household purposes, that's fine, and it's not included. But to be just to point out to you how what a record could constitute. So it's writing on any material. It's photographs, it's labels, markings, a book, a map, a graph. All of those constitute a record. And if the information that you have and the way that you're storing it meets these requirements, then you fall within the scope of the Act, and you need to meet the eight requirements that we're going to be discussing now. All right, so if we can go ahead. Responsible party, as we said, is the public or private body who is holding the information. If we can go to the next slide. So I think we understand now the concepts. And as I said, so once the information that we're dealing with meets all of these requirements, so we're comfortable that yes, it is being processed, it does form part of a record, it is private or personal information, then the Act tells us that there are 8 conditions that need to be met in order for the processing of that information to be lawful. So we're going to discuss each of those, and then you'll see that we have some tips for each of those at the end of the little discussion on it, something for you to ponder. I think just because of our time constraints, I won't cover those, but it's something for you when we email you the slides to maybe take back into your organization and do a little bit of a self-assessment in terms of to what extent you are compliant. So if the first condition of lawful processing is the accountability, as you saw. So there needs to be someone in the organization that is accountable for all of the conditions that we're going to be unpacking now. If you just go to the next slide, you'll see that what the Act expects is that an information officer must be appointed in the organization. If nobody is specifically appointed and that obligation isn't specifically delegated to someone, then that person will automatically be the CEO of the organization. And this information officer's responsibilities are to encourage compliance within the organization. And that's always when we talk about POPI compliance, people say, you know, where do we even start? There's so much to do. And our advice is start there. Start by the appointment of information officer, and make sure that that person's job is to start picking through all of your policies, looking at your contracts, looking at your way of doing things within your organization to see whether there are any gaps. So accountability is crucial. If we go to the next page, so that's the first condition. Sam, you can perhaps ask yourself ones we can maybe just skip past, as I said, and then we can, delegates can have a look at that in their own time. So then the second condition for lawful processing of information is we are limited in terms of how much information we're entitled to process. So process being hold, store, receive, and those limitations are that it may only be done if the person consents. So you'll see consent is a very, very easy and universal theme during the POPI Act, and that's why we encourage people to, in their contract, in their policies, in forms, to always have a little consent block so that people consent to the information being received. Remember, the mere fact that someone's consented to you processing that information, that's only one of the conditions met. There's still a number of others, but that's the first hurdle. So either the person is consented, or it's necessary for the performance of a contract to which the data subject is a member or a party. So again, if I use the medical aid example, if I've got a medical aid broker and we entered into a contract that he's going to help me find the best medical aid plan, then it's necessary for him to fulfill that obligation for him to process my personal information. Remember, processing not only meaning receiving processing as in reviewing, modifying, and all of those other parts of the definition that we unpacked earlier. And you'll see that there's some further ones, ways in which the processing limitation applies. But I think the crux for us to understand is I have to have a proper reason for having the information. If we can just go to the next slide, you'll see that I may only process the minimum amount of information that is required to achieve the purpose that we're engaged for. So I may not request more information that I need. If you think you go to the crazy store, you spend more than 100 Rand, they say, oh great, you qualify to enter the competition. then they may only request the information that they need in order to achieve that particular purpose. So I need your email address and your telephone number so that I can let you know if you've won the prize. They can't then also ask, well, what's your ID number, what's your home address? There's this limitation in terms of how much information can be received. And then crucially, if the individual objects to that processing, they may not continue to process that information. Now, remember, processing means to keep, to use, whatever, however far we want to stretch that definition. So we are entitled to object to information being processed. That also just links up with what I want to say about marketing. So if you receive a call from Vodacom or whoever, oftentimes they have databases of telephone numbers that call you. It means they are now processing your personal information. You are entitled to say, I'm not interested, please delete my number. And that is, I would imagine, and I would trust that organizations are going to become compliant with the Act and teach their marketers that. All right, if we could just look at the next slide, Sam. As we said, ask yourself, you can have a look at this just to do your own little compliance check with your data officer. The third condition is purpose specification. So this is crucial. It's not enough that the person has consented to me receiving the information. They also need to, I also need to take reasonable steps to make sure that the person is aware of why I'm collecting the information. Folks, so now we're also wanting to start thinking about things like COVID, and how everywhere we go, we're now filling in registers. When we enter a building, we put down our telephone number, we put down, our temperature. That's all quite personal information. And I think it's fairly obvious to us why that information is being received, but the point is the responsible party needs to make sure that the data subject is aware of why this information is being collected. And then crucially, I may not keep that information for longer than what is necessary in order to achieve that purpose. So that purpose that I indicated to you needs, I cannot keep the information for longer than to achieve that specific purpose that I indicated to you as being the reason why I need your information. Obviously, there are certain exceptions. If it's required by law for me to keep it, obviously there are certain legal requirements that sometimes apply. It's required in terms of the contract, or you've consented, once again, as you can see. So consent really will go a long way in compliance. So that's the third condition, is the purpose specification. And you can see there, just there's further clarity on that. Carry on then. You can see, do your own little check. So that first, third requirement, as we said, is we need to make sure that people know why we're asking for the information. And then the further processing limitation is I may only, or I am precluded from, as a responsible party, from using that information for any other reason than what the initial consent was for, or the initial reason for collection was for. So it may only be used if it's compatible with the purpose for which it was initially collected. So again, if we go back to the let's take the example of a recruitment agent. So I sent my CV to her in order for her to help me find a particular job. Now, obviously, if she sees further gaps and further opportunities and she sends my CV out to those people, then I would be satisfied that it is compatible with the original purpose for which it was collected. But if she now uses that CV and sends it out or keeps it, even though she's already helped me find a job, then that further processing, remember, just keeping it is also processing, will not be compatible with the original purpose. So it's important that that condition is also met. Obviously, there are certain exceptions and additional comments on that, but that's the crux of the condition. We go on, Sam. Folks, you can just have a look at that in your own time. I'm realizing we're pressed for time now due to the delay. And then, yeah, there's a little self-assessment. Then the fifth condition is information quality. Now, the Act says that you have to take reasonably practicable steps to ensure that the information you hold is accurate. Now, they don't define what reasonable or practical means, but so we'll just have to use our own discretion in that regard. But the crux is that if you take, for instance, a bank, you've applied for a home loan with your bank 20 years ago when you started working, and the payslip they have then is your payslip from 20 years ago. They're not holding accurate information about you. Salary information certainly is personal information, and if that is outdated, then they're not complying with this fifth condition. So it's important that we as organizations take steps to make sure that the information we have is as accurate as possible, so that we don't hold outdated personal information of people, provided, however, that we were authorized to have it in the first place. And then openness. So we need to take steps to ensure that the data subject knows that the information is being collected. That's crucial. Very often we're not even aware that information is being collected about us. So they need to know that the information is being collected, who the responsible party is, so where is my information going to, where can I reach them? Why are you collecting it, as we said? That's part of that third condition. Is it voluntary or mandatory? What happens if I don't give you this information? Is there any applicable legislation? And then any other information that might further elucidate this for me. So it really is, it's not enough to simply get the information and get their consent. The person it has to be informed consent, so to speak. So the person needs to know what this information is being kept for, and crucially, that it is being processed at all. We can just go on, Sam. There are certain exclusions where a person doesn't have to be notified. So that's where there will be no, I consent, it's fine, you don't have to tell me anything, take my information and run. Alternatively, where there will be no prejudice. I can't suffer any prejudice by you not having told me all of those, giving me all of that information. If non-compliance is necessary for the maintenance of law and order, national security, so obviously you can imagine people being, telephones being tapped and that sort of thing. If there's an ongoing investigation going on, then obviously certainly there will be an exclusion in that regard. For SARS purposes, in case of an emergency, certainly then it would also be excluded. So obviously there are exclusions, but the principle is the data subject needs to be aware of the information being collected and what it's for. Then security safeguards, folks, and I think this is where we need to get experts in, and that's where there are many great companies who are able to assist you with this. But in terms of condition 7 is there have to be security safeguards in place. You need to make sure that the information that you have at your disposal is secured. So if it is simply in terms of all of the information you have is in a filing cabinet, then make sure that you have policies in place, you've got keys, it's regulated who has access to that filing cabinet with all of the information. But I think especially now that, as we've seen with COVID, everything's become digitalized. We've all very, very quickly adjusted to a digital, apart from me it seems, but the rest of us have all very quickly adjusted to doing things on our computers. And therefore, we really have to make sure that our organizations are keeping up in terms of the security safeguards. So as much as we're saying we have until next year to become compliant, we really have to acknowledge that this is going to be an ongoing process. As our organizations change, as our operational requirements change, as our way of doing things within our organizations change, we are constantly going to have to be adjusting our security safeguards in our workplaces. We have to make sure, as you can see there, the Act defines it really nicely for us, what needs to be prevented. But again, when people say, where do I start? This all seems like a tall order. I have to get an IT company in. Start with something simple as a clean desk policy. Start off with making the rule that when everybody leaves their desks in the afternoon, everything is locked away, no papers are lying around. And obviously in a digital sense, making sure that flash drives, those sorts of things are safely locked away, encrypted where possible, in order to ensure that you are maintaining security for the information you have at your disposal. You can just carry on, Sam. Crucially is if you become aware of a breach, of a compromise, you're obligated to inform the regulator. It really is like a naughty child having to go tell their mom that they did badly, but that is the requirement, is you have to let the regulator know, and then also the data subject needs to be informed. As soon as possible after the discovery has been made, there has to be information. And then you can see on the next slide is even a requirement of how you need to inform. So it needs to be done in writing. Even expect you to publish it in news if it's not possible to track down the people. So it really is important that there's notification. We just go to the next slide. So ask yourself, you can just do your little self-assessment in your own time. And then data participation. So this is the right of the data subject to reach over the wall, so to speak, to say, I just want to know, what do you have about me? So that is the 8th condition for the lawful processing of personal information. Your organization has to have measures in place and policies in place that enable people to contact you, to find out, do you have information about me? And a description of what information you have of me and who have you given this to. So any third parties that may have access to that. So that's one of the rights that someone has. And you'll see it carries on there on the next slide. This data participation. I need to be able to request you to correct or delete it if it's inaccurate, irrelevant, excessive, out of date, incomplete. Or I can request you also to delete the information if you are no longer authorized to retain that. So that is the 8th condition for lawful processing. And if you feel that that's not happened, so if you perhaps contacted a responsible party, you've asked this, they haven't complied, then that would be grounds for you to lodge a complaint with the regulator. And that's why enforcement mechanisms are so important, because otherwise it would be very simple just to not comply. All right, so some helpful tips that we have, just as we say, people, I mean, obviously people are, it's overwhelming in terms of where do we start to become compliant. You'll see IT asset disposal system to be implemented. Sam, you can just go to the next slide. Make sure that you've got, as we said earlier, if it's a clean desk policy, that's perfect, but minimize storage. Make sure that your that hard drives are distracted in a responsible way. Things are transported securely. You have trails in place to determine how the information is moved within your organization. And this is really a matter of that information officer sitting down, having a look at what the natural life cycle of information within your organization is, and at every point assessing whether there is a way in which we can secure it more thoroughly. And as we always say, the quicker you distract the information, you dispose of the information, the quicker you eliminate the risk. Private information at your disposal is a risk. So don't keep it longer. There's this hoarding mentality I've heard and I've seen, a hoarding mentality in South Africa. You want to hold on to information. If it's not necessary, let it go, because you're letting go of a risk. And just go on to the next slide. I'm going to run through these. I see we're quickly running out of time. So we also have just some advice here in terms of a clause for you to put in your employment contracts, where employees consent you having and holding and processing personal information. Obviously, during an employment relationship, there'll be lots of exchange of personal information. So there's a bit of a clause there that we recommend you use. You can just go to the next slide. And then draft wording for third-party agreements in terms of providing consent for information to be exchanged with third parties as well. Just carrying on, confidentiality clauses, have employees sign them, have your service providers sign confidentiality clauses as well to cover the basics. Just the next slide, thank you. Crucial, we cannot disclose information that is legally privileged. So to what extent you can disclose information, and this is we see this in the Labour Relations Act as well, in terms of disclosing information. You can't disclose something that's legally privileged. If there's any kind of legal prohibition on disclosing that information, any kind of harm can follow from the disclosure of information, or any private information unless the person has consented to that. Again, what are the enforcement mechanisms? So what happens if the regulator finds you to be non-compliant? The fines can go up to 10 million rand and possible jail time. So it really isn't worth not being compliant. And as I said earlier, there can also be civil claims, and the information regulator can even fund those civil claims if they think that there's merit in doing so. Folks, it really isn't. It's not worth not complying. Just I see I have 2 minutes left before we're done. There's also the aspect of information leaving our borders in South Africa. Now, we think, no, well, I mean, we're just using our information internally. Remember, if we store information in a cloud, if that service sits in America, then yes, the information is leaving South African borders. And the requirement there simply is that you ensure, you inform the data subject that the information is now leaving the jurisdiction of the POPI Act, but that where it is going, there is similar legislation that will be protecting it. And do they consent to that happening? All right. Folks, thank you so much for your attention. And I really do apologize for the delay. It was a mad rush behind the scenes here to try and catch up. Apologize for that. And if you have any question, I'd love to answer them. And we'll do so, as Sam said, in a nice compiled document that we'll be sharing with everyone along with these slides.
Yeah, great.
Thank you so much.
Guys, yes, if there's questions, I'll gladly take them in the chat box, or you can send them through to my email direct. Serene and I will be working through the questions, so for a documented idea of your answers, and everybody's going to receive the answers. So if you've got something that's really, really, good in sharing with us, we'd love to hear from you. My email address is members@bkcob.co.za. I'm here to guide you on all your processes, and Serene's our expert, so we will definitely get the information to you with the video recording as well as our PowerPoint that Serene has shared. Those questions on Serene's PowerPoint, we'll be able to attack that as well in a nice way. So if you've got any queries on those questions and you'd like some more information, Serene will guide us best. All right, so
thank you so much.
Yeah, I appreciate your time, Serene. Thank you for joining us.
Thank you. I apologize for the delay again.
Yeah. All right, guys. Yeah, you can chat away for me in the text box. I will stay online for a few more minutes, and then I'll try and get all the questions off here through the recording. Otherwise, on my email. Have a great day further, everyone.
Thank you.
Bye.
Just see Liz's comment there.
Yeah, thanks, Audrey. My comment, Sam, was can the participants get a copy of the presentation? I don't know if that was mentioned earlier. Perhaps I didn't hear it, wasn't listening. Was it mentioned?
Yes, it
Holy
was.
smoke.
No
I
problem.
obviously wasn't listening.
Presentation, recording, and a question documentation for the panel. If there's any questions, we'll
Okay.
help everybody.
Okay. Okay, cool. So, okay, that's fine. So you've got everybody's email address, eh?
I do. It's all on the RSVP list, so I appreciated everybody coming on board today for this. So, I'm sure everybody, if there's going to be assistance on their policies and their documentations, whether they're in part of the school or a normal business, they will be able to get all of that information and correctly insert it onto their documentation with the help of Serene and the team at Global Business Solutions. But please do remember, if there's members on board, the Chamber is here to guide you. We can drive those communications for you from a Chamber benefit side of things. It would be great to hear from everybody that was online. I will share shortly.
Okay, I see there's still some people in the room. I'm not sure if they're questions, so I'm going to duck out of this one. Thank you, Sam. Well done.
Thanks for joining. Great. Staff of Selborne, it was great having everybody on board. Thank you for joining, Angie, and for Shanae. Andrew, thank you for coming on board. It was great to see you guys there. Okay, I'll follow up with a personal email to everybody as well, just to make sure that everybody is comfortable with their questions. They can send their questions direct to me on email. But other than that, I'm going to sign out. Thank you for joining the Chamber. It's great to see everybody there. Enjoy the rest of your day, everyone. Bye.